Real estate agents regularly deal with contracts. They need to understand the basic elements of a contract and how they'll differ based on the specific circumstances. Let's go over some general parameters of contracts, as well as their basic parts as related to real estate. First, for a contract to be valid, it must have legal purpose. This may seem obvious, but it needs to be stated that the contract's purpose can't be achieved through illegal activity. Legal purpose specifically means that performance of the contract is not in and of itself unlawful, and therefore the contract will not result in a violation of the law. A sales contract for a stolen car or an employment contract to steal cars for compensation is probably not going to hold up in court. All parties to a contract must be competent. While you might think that this simply means someone of sound mind, the legal definition specifies the characteristics they must have to enter into a contract. In real estate, all parties to a contract must be 18 years of age or older. Individuals must not be operating under a legal disability, such as a court-ordered guardianship. And finally, for business entities like corporations, limited liability companies, and limited liability partnerships, parties must be in compliance with state requirements by filing annual documents and complying with assumed business name requirements to legally be able to enter into a contract. So, now that we know the contract is regarding legal matters and all parties are competent, what else do contracts involve? Contained in the body of most contracts will be clauses or terms that define other specifics of the agreement. Things like contingencies, as well as other stipulations and limits, will be defined in the body of the contract. This is also where the term consideration comes up. Considerations are what one party offers to do if the other party performs the obligations set forth by the contract. Usually, consideration is offered by one party in the form of money and the other party in the form of an action or inaction or for property. For an agreement to progress and be signed into contract, there needs to be a mutual accord. In simplest terms, an agreement is made between one party presenting an offer and all other parties involved accepting that offer. The acceptance of an offer is signified by signing the contract, which is an agreement to the exact terms as expressed in that contract.